You finally get an offer from an insurance company, and it's not even close to covering your bills. You stare at the letter wondering, is this normal? If you're supposed to just take it and move on? But if you accept that without pushing back, you could be stuck paying for thousands of out-of-pocket medical bills for an accident that wasn't even your fault. At Blackburn Romey, we help injured clients across Indiana respond the right way so that they don't get pressured into bad deals. This video takes you behind the scenes, and we're going to walk you through step by step so you can fight for your case and for what it's actually worth and avoid being lowballed into silence.
So after you're in an accident, you're going to there's a lot that's going on, but one thing you're going to have to do is deal with an insurance company. It's really a strategy now that we see with at least a couple different insurance companies right now. State Farm is one of them. Progressive is another, where they will call you pretty quickly after an accident. And you see this in accidents without catastrophic injuries, but in sort of, let's call them minor collisions, they'll make an offer pretty quickly. And it's usually low, $500, $1,000. But what they'll also do is they'll tag on and say, if you incur some additional medical bills in the next 6 months or whatever, we will pay for up to $3,000, $4,000. I've even seen up to $15,000 of medical bills going forward, which sounds great until you actually incur an extra $15,000 of medical bills.
Or especially if it's right after and the pain really hasn't started to kick in yet.
Yeah, and so it sounds, oh, well, they're looking to take care of me. What they're really doing is they want you to take that $500 for the pain and suffering, saying, well, gosh, even if you have another $15,000 of medical bills, they're still getting out really, really cheap for that type of case. It's those quick settlement offers that make almost no sense because they don't know what your case is worth, and you don't know what it's worth because you just got in the accident. I had a client that came to hire us. She got an offer for $300, and it was not a huge accident, but she had neck pain. She was going to go through some physical therapy. They gave her a $300 offer, and she was just offended. Now, she was looking to resolve her case without us. She hired us, and we worked the case up and eventually settled for $25,000. Now, you don't see that type of disparity all the time, but these are the types of things where she had a valuable claim, and they were trying to get her for pennies on the dollar. They just offended her. And frankly, she probably would have settled for a lot less than 25 if they didn't offend her so much with that first offer. So it's you do really have to be careful when you hear that quick offer. You might be in a spot, gosh, I'm out of work. I got rent or mortgage to pay. I got bills to pay.
Got to put food on the table.
Yeah, that $500 really sounds nice. But again, you might be leaving a ton of money on the table just to get it done quickly.
I think that's one of the things that we see time in and time out is the strategy that insurance companies use to try to get people to sign off on their case really, really, really quickly. Chad, what's one of the main reasons insurance companies try to do this?
Well, it's to obviously limit their exposure on the bigger cases. So, insurance companies, as you know, they're for-profit businesses. Okay, they're trying to make money. And if they call up every single person who was in an accident and offer $1,000 to that person, they might end up overpaying on quite a few of those, especially to people who weren't injured. However, you and I have both had clients come in where they say, hey, look, I settled the case already. I haven't hired anybody. I settled the case for $750. But here I am 6 months down the road through physical therapy, and now my doctor is recommending I need a surgery, and that surgery is going to cost $120,000.
Now what do I do?
Yeah, what do I do? Can I open my case back up? And no, you can't. And let me say, in almost every single scenario, you can't. There are probably a few exceptions there where you might be able to. However, so even though an insurance company might have overpaid on some of those cases where they paid $1,000, they only have to save one of those cases where they would have ended up paying $500,000 or $1 million, but they got out of it for $1,000. Right. And so it makes a lot of sense for insurance companies. It's risk analysis for them.
Yeah.
How do they make money over the course of all of their cases, not necessarily on one particular case?
Absolutely. I think they look at it from a whole, and if they can try to minimize their risk, get these files settled really quickly, and get the check out of the way and not litigate these things, then in the long run, it's a strategy that pays off. Otherwise, they wouldn't be doing that. But let's kind of pivot and change gears here. And let's kind of pull back the curtain of the veil. Let's talk about some of these secrets that you guys can do to try to counteract those low settlements. So one of the first things is simply going to be you've got to gather your evidence. Simple as that. And evidence, and we've talked about this before, but evidence is going to be pictures of the scene, pictures of if you're in a car accident, pictures of the cars at the accident. You can do a video. You can walk around. You can keep the video going while you're talking to the police officer. Or you're talking to the defendant. Pictures are going to tell a big story.
Pictures of your injuries are really important. They tell the story better than your medical records will, a lot of times.
Absolutely. Then you start shifting into your medical records. Medical records aren't just your bills, but they're also what do the doctors say in your record, but also what do you say in those records as well. So gathering of your evidence is going to be really, really, really crucial. And it can be on some of these simple cases as simple as medical records, medical bills, and then the pictures of the vehicles and pictures of your injuries.
Yeah, so that's how you're going to prove your case. Then the question comes down to what's it worth? What's it worth? So you can go out there online and find websites that will tell you, hey, here's our settlement calculator. We're going to tell you what your case is worth. It's not that simple.
I use those all the time. I mean, that's part of my practice.
Yeah, it's just you go out to the random online calculator. Is that what you've been doing?
Yeah. Injurycalculator.com.
Yeah.
Check that out.
Yeah. So there's a lot of different variables that go into what is your particular case worth. Where did it happen? Whose fault was it? Are there arguments that you might be partially at fault? Medical bills, both your current medical bills, the ones you've already incurred, and the ones in the future. Believe it or not, how much your health insurance paid, what your health insurance reductions entitled you to off your medical bills, lost earning capacity in the future. And then you get to the fuzzy stuff, pain and suffering.
Oh.
All right, what's that worth? And that's, again, there are people out there who might tell you, well, if your medical bills were $10, then your pain and suffering is worth 3 times that amount. That's a very inexact science. Medical bills, by and large, don't correspond to how much pain you were in. So there's a lot of figuring out what is the case worth, and you might have a good number. You might nail that exactly, and then there's the convincing to the insurance company of paying the right amount, and that really is where the rubber meets the road.
The big concept I run into a lot with my clients or potential clients is they do want to know what their case is worth right off the bat. And frankly, if you really want to know what your case is worth, you're going to have to take it to trial, and it could be 10 different responses with 10 different verdicts. But at the end of the day, it's hard to say what a case is worth without actually seeing the documentation and seeing the medical records, seeing the bills, looking at the type of treatment that the plaintiff, that my clients went through, the duration, are there gaps? There's a lot of things that go into it. And so even the clients that I talk to day in and day out, that they're frustrated with the process and they want to know what the value is, I tell them frequently, I don't know until you're done treating at that point. Once your case reaches a point where you submit or you yourself get an offer from the insurance company, then you're going to have to really analyze yourself in terms of what do I think this is worth. But that's where in terms of the value of your case, you can expect if you handle these claims on your own, the insurance company is going to give you a lowball offer, and you're going to want to reach out to an attorney to find some guidance in terms of, is this offer something that makes sense or doesn't. Jen, I've had cases too where someone walks in, they say, hey, I got this offer, and based on what they tell us, there's times we'll say, that's a pretty good offer. I don't think I can help you. But that's not the norm. The norm is absolutely lowball offers.
Yeah.
It kind of touches with, well, if you get an offer from the insurance company and you've been handling this case by yourself and you get that offer, are you stuck with it? And you're not. You can negotiate yourself, and we can kind of pivot and talk about things that you should do to be able to do that. But it just goes to show you that no, the offer that they give you isn't the first offer. It's not until I always use the adage, Ronald Reagan talking about trust but verify. Until they tell you that this is the offer and they tell you about 3 or 4 times and it doesn't change, then you know that that really is the offer.
Yeah. Yeah. So the next step then, if they make an offer, what are you going to do? Well, you can either accept it, reject it, and do nothing, or you can reject it and counteroffer, which means, hey, they've offered you $10, but you want $20. And so you're going to write a letter. You're going to write something to say, here's why I deserve more money. Here's why my claim is worth more. I will also tell you, it doesn't matter what number you put on it, they're not going to say yes, right? So even if you are really, really reasonable, I once had a client hire me. All she wanted, they had offered $1,800. All she wanted was $2,000. All she said, if they would have just paid me $2,000, I told them I just need $2,000. And it was a small case. We ended up settling it for 10. They refused to pay her the additional $200. It almost doesn't matter what you demand. Usually the answer is going to be no. So, but that said, in your counteroffer, you're going to tell them why their offer is too low. You're going to tell them why your offer is fair. I will also say it doesn't matter what the number is, no matter what they offer you or what you demand, none of it is worth it. Meaning, at no point are you going to say, wow, I'm glad I got this broken leg.
I want to do that all over.
Yeah, what I have another leg to work on. Let's do that one next. So at some point you do have to evaluate your case value, not your injury value. And those are two different things. Your case value is what's reasonable in the light of the civil law in the jurisdiction in which you live. What's the reasonable amount? What are people like you received in similar circumstances? At no point will you say, how much is it worth to get that broken leg? It's a hard thing to wrap your head around, but that is the analysis.
Specifically nowadays, I mean, in the days of writing letters, they're not necessarily over, but they can be helpful because it's going to it's going to make it a little bit more formal. A lot of the negotiations that you guys would do, that we do, it's all verbal or through email. And basically when you outline that and you're making demands, one kind of trick, if you will, is to look at what the offer is and then structure your demand high enough that it leaves you plenty of room to negotiate. But also you want to look at a midpoint, because if they're offering 20 and you start out at 60, well, what's halfway? 40. So you're kind of sending a message to the insurance company that you might settle at 40,000. They may not pay it, but you're sending the message. So those midpoints are going to be helpful when you're negotiating with your cases.
Yeah, and when you are negotiating, because you're going to be producing documentation to them, you're going to be giving them medical records, medical bills. You might be giving them access to all that as well by signing authorizations. If you believe that, you know what, I'm going to negotiate to see where they can get, but I'm most likely going to hire a lawyer at some point, I would encourage you to do none of that.
Mm-hmm.
Meaning, let the lawyer do it. Because if you think you're going to hire a lawyer eventually because the lawyer will get me across the finish line, well, you don't want to make mistakes in between the starting line and the finish line that your lawyer has to try to undo. So know when to get legal help. That is really important. At the end of the day, you have an asset. Your asset is your case. And you are, if you're going to settle it, you are selling it to the insurance company. So lots of times people get realtors because a realtor is really good at selling houses. And
they understand the market. They understand who's buying, who's selling. They want that sort of thing.
Helps you get your top dollar. And so I think even more so in this case, in injury cases, a lawyer is even more important than a realtor is to selling a home, because there's a market for homes. Everybody knows what homes are worth. Nobody knows what broken legs are worth, right? So meaning there's not a market out there for those things. And so having somebody in your corner to be able to help you evaluate is really, really important.
Yeah, I think the lawyers like us at Blackburn Romey, I mean, outside of our experience, and we've got well over 50 years with the attorneys in our law firm. We've been to trial, so we understand some of those jury verdicts, but we've got access to some databases as well. And so knowing when to hire an attorney, I would agree with Chad 100%. If your mindset, if you're even just tipping the scale, I think I'm going to hire a lawyer, go ahead and do it. Because one of the most complicating things or most complicated cases, or our cases, are where our clients maybe initially consult with us, try to do it themselves. They get stuck, and then they come back a year later or a year and a half later and say, oh, now can you help me? So one, they're at a disadvantage because they've already, I guess, wasted a year and a half. But then two, they've kind of maybe said some things to the insurance company that kind of box them in a little bit. So I'd say if you're at that standpoint, or if you're at that mindset already and I'm going to hire a lawyer, just go ahead and do it. The lawyers any lawyer will take that case compared to strike that. Just go ahead and do it.
Yeah. Yeah. I mean, not every case needs a lawyer, but some definitely do. And if you're not sure, call a lawyer. You have 2 years from the date of your accident or the date of the injury to either settle your case or to file a lawsuit to preserve your claim. If you're getting close to that 2 years, the closer you get to the 2 years running out, the fewer lawyers that are going to take your case. So don't call your lawyer or a lawyer a week before the 2-year deadline thinking, you got plenty of time, it's a week. Well, it's really not, because there's a lot of dots that we have to connect in order to file an appropriate lawsuit. So give your lawyer some time. There are most lawyers who do what we do, which is work on injury cases, work on contingency fees. So sometimes the hesitation is, well, I don't want to call a lawyer because it's going to be really expensive. And gosh, I don't have the money. I'm out of work. I just got into this accident. Most people who do what we do work on contingency fees, meaning if we settle the case for you, or if we win a jury verdict for you, we get paid a percentage of that amount.
Absolutely.
So what's really important to remember, and where a lot of people have a hard time getting over that mental hurdle, is that calling a lawyer is not necessarily an escalation.
Doesn't mean that you're going to have to hire a lawyer or that the lawyer would take your case. But what it does do is it arms you. It's going to arm you with some knowledge, just like this video does.
Yeah. I've had a lot of clients who are almost apologetic for hiring us. I didn't really want to call a lawyer because I didn't want to be that person.
Yeah.
Okay. So calling a lawyer is not necessarily an escalation. Now you're doing something. It's just a strategy. It's you getting advice to see if it makes sense for you to pursue your claim that way. Some lawyers will tell you, hey, yeah, your claim doesn't need a lawyer. You don't need a lawyer to resolve this claim. But if you have a complicated case at all, absolutely get a lawyer involved early.
So why don't we just maybe recap a little bit here about kind of some of the tips and tricks that we've come up, or we at least discussed in this video for you guys. So inevitably you're going to get low settlement offers. It's just the nature of how these things work. We get low settlement offers pretty much at every stage. It's not the first offer that matters, it's the last one. Once you get your low settlement offer, then you're going to want to counteract that by writing a strong counter offer. Before that, don't forget, you're going to want to document, collect all your evidence so that you can use that to be persuasive in terms of what your case is worth. And then, as Chad mentioned, you want to seek out legal assistance on those cases. And certainly you can do that from the very beginning.
Now, if you found this helpful, check out our next video, which is how do I know if the truck driver was at fault for my truck accident? Because proving fault is the key to getting the settlement you deserve, especially in big vehicle cases where special types of evidence can exist. Don't risk missing out on what you're owed. That's all we got for you today. Thanks for watching.